Yes, now. Yes. So all of this nice introductory stuff was just for you live, and you can never get it back in listening to the recording. As Jana said, I am Kati Pino. I am a senior associate at Hedman. You might ask, so why am I the one qualified to actually tell you about anything? Well, this is just a small sample of startups that we have previously advised or are currently advising. So you can see that there are quite a lot of usual suspects in here. So I know a thing or two about startups and the legal problems that they face. So today, I will not be going over all of this that is on this slide. I will mostly be talking about the shareholders and founders agreement, and maybe then, if we have the time, go over the cap table do's and don'ts. I can share all the slides with you if you want to, but for the other ones, you will just have the slides. Sorry. Okay. So, a shareholders agreement. As the name suggests, it's an agreement between the company's shareholders. And it protects both minority and majority shareholders' interests. You may also see that there is a founders agreement. A founders agreement is essentially a more simpler version of the shareholders agreement. In case of a shareholders agreement, you usually have founders, you have some investors, maybe you also have some employee shareholders. But in case of founders, you only have the founders. If you were to conclude this agreement today, I suggest that you conclude the founders agreement because it's just simpler. But generally, they are the same. So here is a bit of comparison. So the founders agreement is less complex. It generally has less parties as well. It does have less minority shareholder protection, if any. So if you are only among the founders, then you might not need minority shareholder protection at all. And generally, the governance is pro rata. So who has more shares has more votes. As if in case of a shareholders agreement, there is more complex structures used. There is minority shareholder protection because in case of investors, they will become minority shareholders, so they can't really rule based on pro rata. So they require some kind of veto rights, even though they have less shares than the founders. It also includes usually anti-dilution protection, which becomes more and more important if we actually enter into a downturn in the economics. So shareholders agreement, generally more complex, founders agreement, a bit lighter on the regulation side. Why is it a good idea to conclude a shareholders or a founders agreement? I generally use shareholders agreement, but I mean both of them. In Estonia, I know not all of you are Estonian, but in Estonia, if you want to get married and you go and submit the application to get married, you need to think about what happens when you get divorced. And this is the same when doing business. So when you are starting to do business with your co-founders, you need to think about what happens if we part ways in the business. If it doesn't take off or whatever happens. I mean, life happens in more ways than we can imagine. You should also be guided by the principle that if everybody is responsible, nobody is responsible in the end. So if you have just general understanding that everybody does everything, then there is nobody to pinpoint, nobody to blame in the end. So having a clear division of responsibilities is generally a good idea. And as always, the devil is in the details. So your case is absolutely different from all the other cases, and there is no such thing as a standard case. So you need to think about what makes your business and what makes your current state so unique, and what you need to regulate in this case. I forgot to mention in the beginning that if you have any questions, then you can shoot as they come up. You can write them in the chat, or if you're brave enough, you can also turn on your mic and ask them using your lovely voices. Another why of a shareholders agreement is that it is confidential. So whatever you have in the shareholders agreement is just between the parties of the shareholders agreement. So it's not a public document. Currently in Estonia, the commercial register is completely public. So everybody can go and look at the articles of associations of the companies. But the shareholders agreement is just between the parties of the shareholders agreement. Contents of a shareholders agreement. I mean, it can differ, but this is generally the idea what is included in a shareholders agreement. First of all, the roles and responsibilities of the founders, then the ownership structure, who owns what, management of the company. It is different in when the company is actually founded, or in the pre-company stages, it's a bit different. Reverse vesting and founder commitment, how to make sure that you are actually equally devoted to this idea and nobody leaves, or what happens if they leave. Share issues and transfers, how the shares are actually transferred, what kind of rules apply, are they freely transferable, or are there some restrictions to it? Option pool. Do you wish to have an option pool? Do you need an option pool? Is this something desirable for your employees? And then we have also important confidentiality, how to keep your competitive edge and your business secrets. Non-compete, non-solicitation, how to keep the team, how to keep the uniqueness of the idea. And then just some boilerplate clauses about representations and warranties and final provisions. They are pretty much the same among most agreements, but still, as I said, devil is in the details, so these should also be read. So we'll just go into this one by one. Roles and responsibilities of the founders. So first, why would you regulate this? As I said earlier, that you need to have responsibility, you need to have people who are accountable for certain things, because otherwise the ball is very easy to drop, because nobody takes accountability of some kind of an issue or some kind of a field that you need to have managed in the company. How detailed should it be? It should be as detailed as needed, but don't go crazy, don't go too detailed, because if you are doing a startup, then you are already well aware that the roles can switch between people, and it might happen that everybody does everything. So if you go into very minute details, then it just might not be practical. It is important because it ties in with the reverse vesting and the commitment of the founders. So if you have very clearly set boundaries between different areas of responsibilities, then you can pinpoint who is the one to blame if the ball eventually drops. And then you can take measures against the person who has dropped the ball on their end. Now I have some examples for you, so you can see for yourself how other people have decided to regulate this in their agreements. These are all real examples, so I didn't make them up. I just removed names. So in this example, you can see that there is some regulation, but it is still rather difficult to say who does what. okay, giving directions to the management board is rather straightforward, but whether or not motivation is provided to the employees and innovation done in current and future business relations is rather difficult to actually measure. And for the other founder, it's also quite difficult to measure, but at least it shows that they have thought about it. Another example saying that one of them is a head of operations and the other is a head of product development. But the business is not just operations and product development. There are so many other tasks that need to be covered. And if this is the division of the roles, then it's not clear who is actually responsible for the other roles. Example number 3. So here is a lot of overseeing and implementing, and just I would say that how to measure if things have been overseen or not is very, very difficult. So it's very hard to say that somebody has failed or somebody has excelled at their duties if you use this wording. Ownership structures. Since you are online, I can't really do this, but usually I ask how many of you are 2 founders and with a 50-50 split. I think there might be a few amongst you as well.
Sorry, can I ask a question on the previous one?
Yeah, sure.
So which example was the best?
Well, none of them are very, very good in that sense.
Okay. A very good example?
I can't really give you a very good example, actually. Okay. This depends very much on the business and the stage of the business, and also the people you're doing the business with, because some people really like the C titles. So it might also be just CEO, CFO, COO. But if you don't really furnish these terms, then it's yet again very difficult to say who has to do what. Okay.
Yeah, thank you.
In this case, I'd actually think that maybe the first one is the best.
Okay, yeah, thanks.
Any other questions? Okay. Well, regarding the ownership structure, if you have a 50-50 split, this is the most difficult split to be in if you don't have a shareholders agreement, if you leave it up to the law, because at least under Estonian law, the general principle is that you need more than 50% of votes to adopt any resolution. 50% is not more than 50%. So if there is a 50-50 split, basically you need to have a consensus on everything. And as we know, if things go well or if things go really badly, then the consensus is very, very difficult to reach. So if you have a 50-50 split, you need to think about the divorce even more than in other cases. You need to think, so what happens if we don't agree anymore? How do we overcome this deadlock? There are multiple possibilities to do it. I mean, the worst thing to do is not to think about it at all and say that, hey, we've been friends 20 years. We're going to be friends for the next 20 as well, no matter what happens in the business. Unlikely. So if you have a 50-50 split, think about how you're going to resolve the deadlock. There is no right or wrong way to go about it, but you just need to have a way that the both parties agree to. It can be as simple as flipping a coin, but it can be way more sophisticated, but it just needs to be thought about. Other than that, there is no right or wrong way to structure the ownership. Everybody needs to feel that they have been treated fairly. So if you can achieve that in any way, it's possible, and there is nothing in the law saying that you can't do this or that. I have some examples for you again. also real life examples. Now the Estonian commercial register shows the ownership of companies in this nice pie chart. Usually there is also names attached to it, but I have deleted this, so you can't very easily find which companies I use as an example. So in this case, you can see that one person has almost 54%, one has 35%, there is an 8% and 2.4% shareholding. In this case, in the absence of a shareholders agreement, then the one who holds the 54% can make most decisions and doesn't really have to consult with other shareholders. And for some central decisions, a greater majority of 2/3 is required. So if the two bigger shareholders band together, they can basically run the company as they wish, and the other ones don't really have a say. Next one. One person has, well, it's not actually 100% rather than 99.999 ad infinitum, and the other person has just a very, very small share. Possible? Is it fair, you might ask? Well, very stupid lawyery answer, it depends, but this is a real life existing ownership structure, so I guess it seemed fair to the guys who did this. Number three, 60/40. Well, in this case also, in most cases, the one with the 60% can rule the company, and only in some central decisions has to ask for the 40% owner to be on board as well. Management, how do you actually make those decisions?
Sorry, can I ask?
Yeah, go.
Yeah. So basically, let's say there are just two founders, and they're like very kind of equal. So then the best option is like go 51/49.
I'd say so, yes.
Okay, thanks. Yeah.
But you know, in reality, the situations where everybody is very equal are very rare.
Yeah. Okay.
I also have a question quickly.
Yeah.
About the, I don't know how's that in English, but we have this põhikiri when we establish a company, and there you can actually also put some things that I don't know, you need like 2/3 of the board to make some sort of certain decisions. So how do these two documents like work together, or how to make them work together?
Yeah, the articles of association are either like a part of the shareholders agreement by reference, or all these agreements that are in the articles are incorporated into the shareholders agreement. Mm-hmm. So this is how they work together. Generally, how I work at least is that in the shareholders agreement, I have a sentence saying that the principles about share transfers and the adoption of resolutions are set forth in the articles, and then just have all these topics dealt with in the articles.
Okay, so I managed to get myself into an interesting position just a little time ago where it was 51/49. But we said in the articles that in order to do some certain decisions, including to shut down the company, we need like 66% of the shares, because we thought, you know, we will very soon have new shareholders, but eventually we didn't, and then we parted. So then I had a big question in my head: what does that mean now? But eventually we came to a resolution that we're gonna shut the company. So, but yeah, that was an interesting situation.
Yeah, shutting down the company is one of those resolutions that requires 2/3. This is required by law. If you want to have a resolution shutting down the company, you can't have the threshold lower than 2/3. So this is why you run into this problem. And there are also some other central resolutions like mergers and division, and changing the articles also requires 2/3. So you can have the threshold higher than the 2/3. So it's like 67%. You can have it higher, but you can't have it lower.
Okay, thank you.
So going into the management, well, general principle is that the majority rules. But it's also possible to rule on a consensus and also have minority vetoes. So, yeah, majority rules means generally that more than 50% have to be in favor of the resolution. Central resolutions require 2/3, and it can be set higher than what is the minimum as required by the law. So you can have that whatever resolution we adopt, 70% need to be in favor. This depends on the share split that you have, and in some cases it is reasonable, in others not so much. And you can also have different thresholds for adopting resolutions. You can have that, let's say that, you know, some resolutions are adopted at 50%, some are adopted at 75%, and then some require 95%, depending on the severity and the substance of the resolution. So there are a lot of ways to mold it according to your needs. And again, there is no right or wrong way, but there is just more practical and less practical ways.
There a question, but then it should be always higher than required by law, right?
Yes, it can't be lower than the one required by law.
Yeah.
So that's like the absolute minimum. You can't go lower than that.
Okay, thanks.
Consensus is a fun way to run the business. Usually it is used mainly in pre-company stages. So if you're still like in the formative stages of the company or the business idea, if it's only like the central 2-3 people who are working on it, and they have a clear outlook of where the company or where the idea is going to go. If it's used later, it generally creates more problems than it offers solutions. Because if there are more people involved, reaching the consensus is more difficult. Sometimes even if at first we have a clear and shared idea of how we're going to do it, later on it might differ among the people. So use consensus when there are a few people and you know that everybody is on board, but not much in later stages. Vetoes. Vetoes are a way for a minority to have more influence over the resolutions. So if somebody, for example, has the 9% that we had in the first example, but the articles and the shareholders agreement say that in order to adopt a resolution to increase the share capital, that shareholder needs to be in favor, then you can't adopt the resolution even though their percentage is low. Usually vetoes are introduced by the investors, and the founders themselves don't usually have agreements including vetoes, unless there is some power imbalance between the founders. And maybe, for example, somebody has contributed a lot at first, but then later on becomes less and less involved, then maybe the others need to have a bigger say than the original author or the original idea generator would have. Vetoes can become limiting and impractical at times. If you have everything under a veto of a small shareholder, then just the governance is slowed down. So So just tread lightly in this case. Investors like to have vetoes, but just the scope of their vetoes should be curbed. So just be critical and try to understand why they want to have this veto right. There is always a why. Reverse vesting. Have you heard of it before? I'm guessing everybody has heard or nobody has heard of it before. So I'm going to take a wild guess and say that at least most of you have not heard of it, who are not serial entrepreneurs in the startup field. Reverse vesting means that if the founder stops contributing to the company, then their shares can be bought back from them. It depends on the circumstances, what is the price payable for such buyback shares. But this is the tool to avoid dead equity. Dead equity means a part of the equity belonging to a person who is not active in the company anymore, but would very much like to share in the proceeds and the upsides of the company. This is required by the investors, but is also a good idea to introduce in the founders agreement that is concluded just between the founders. Why is that so? Well, if you start out, everybody's like, yes, we're gonna do it. We're gonna take over the world. We're gonna devote all our time and money and hours of sleep to this business idea. At first, yeah, maybe everybody does that. But then Euribor rates are going up, the price of everything is going up, then maybe the person needs to take time off or just loses the enthusiasm, loses the possibility to contribute as much as they did before. But if the others are still interested in working on the company, working on the business, then they don't want to have this dead weight in the capitalization table in the ownership structure. If you have reverse vesting provisions included, then you get to buy out such a person. It depends on whether there is a good lever or a bad lever. So if the person is a good lever, then general idea is that their unvested shares can be just bought back for nothing, so they have to give them back, but the ones that are vested need to be bought back from them for fair value of such shares. There is a problem written into it because nobody really knows what is the fair value of shares of a company that is not publicly traded. And yet again, there is no right or wrong way to go about it. You can have an independent expert tell you what is the fair value. You can just have a shootout style bidding war and take a median of it. You can use some EBITDA or other financial calculations to determine the fair value. No right or wrong way, but just agree on something at least. Reverse vesting schedules can differ. The Estonian market standard is having it over 3 to 4 years. So if you leave before the 4 years are up and you are a bad leaver, you have to give back everything. If you leave and you are a good leaver, then it depends on the time you are leaving. What is of note regarding reverse vesting is that the reverse vesting clock can be turned back multiple times. So if you are subjecting yourselves and your co-founders to reverse vesting now and agreeing that, yes, the reverse vesting period is 3 years, but after 2 years you have an investor, the investor can come in and tell you that, hey, I want to have the reverse vesting for another 3 years or maybe 4 years. And this can be done. There is nothing in the law that says otherwise. And the investors do like using it because they want to ensure that the founders are devoted and still engaged with the company. There is a hand up And since I can't pronounce your name, please just take the microphone.
A little bit feel like I misunderstand what means to take a reverse vesting by shareholder or investor. What does it change?
So if well, this is all under Estonian law, and it might differ in under other jurisdictions, but if a shareholder has the shares, it's if you leave it to the law, it's rather impossible to actually get the shares back from them under any circumstances. There is the possibility that if the shareholder has damaged the company, but I have never seen it used in practice. So it's a very high threshold. So if you don't have reverse vesting in place, and let's say you and me are in a company and we have the 50-50 split, and I decide that I don't want to do that company anymore, and I just drop everything and go live in the Bahamas. You can't do anything to get the shares back from me. So the company is still set with the 50-50 split. You need to have me voting on everything. You need to pay me half the profits you have. So you also need my votes to shut down the company, as in the previous example that one of the audience members shared. So you don't want that such a situation. But if there is a reverse vesting, and if I leave and tell you that, hey, I don't want to do this anymore, I'm going to the Bahamas, then you can say like, okay, you're a bad leaver, you need to give everything back. And you get everything back to the company or yourself.
And by law, how many years is given to be like a good leaver? How many years after?
Usually the whole vesting period is 3 to 4 years. But you can become a good leaver at any point in time. Then just the number of vested shares differs. If you become a good leaver at 4 years, then everything is vested. But if you become a good leaver at 1 year, then generally like 25% is vested if the whole vesting period is 4 years.
And it's like referred only to investors, yeah? It's talk only about investors or founders?
This applies to founders, and I would suggest that you also include it in the founders agreement. So when it's just the founders, then also include this. But investors also want to have it included in most cases.
Understand. Thank you very much for clarification.
You're welcome.
Yeah, and Kati, one question I had, just to be clear, I understand correctly, this is multiple times clock.
Yeah.
Could you maybe give an example just to make it clear, because yeah, I think it's quite important.
Yeah, sure. So let's say that we agree on a reverse vesting of 3 years today. So if we agree on it today, it would run out December 2025.
Yeah.
But if we have an investor coming in, let's say June 2024, the investor can say that, hey, I want reverse vesting of 3 years. And then we basically like restart the clock in 2024.
But does it mean that half of the share is basically 50% of the time, right? So it means that everyone already got half of the shares?
Depends on how good of a negotiation position you're in. If this is your first investment, then you probably don't have room for negotiation saying that we already have the 50%. Okay. If it's in a later round, then it is more likely that you can negotiate the position that some of the shares are already vested and not subject to reverse vesting.
Wow. Is it an Estonian thing or it's also international?
It's international.
Okay, wow. Good to know. Thanks.
Yeah, I mean, in the later rounds, the investors don't really care about it. Like in the A and B rounds, they don't really care about it because then the company is strong enough. But at least in the beginning, the founders are the company basically.
Yeah. Okay. Thanks.
So this is about reverse vesting. Share transactions. How we actually transfer the shares. If you look into Estonian law, then share transfers are subject to right of preemption, and that's it. Also preferential subscription right, but there is no drag along or tag along. I will go into the importance of them right away, basically. Preferential subscription right. Under Estonian law, this is granted by law. Basically, this means that if the company is to issue new shares, the current shareholders can subscribe for the shares in the first order. So in order to keep their shareholdings, they can subscribe for the new shares. This is just the logic of the limited liability companies being closed companies. So if you are a shareholder, first you get the right to subscribe for the shares in order to keep your shareholding before such shares are offered to any third person who is like outside the circle of the shareholders. This is a rather nice thing to have if you are a shareholder and if you are looking to keep your percentages in the company. Generally, if an investor comes on board, then nobody really wants to keep their shareholding percentages, because if you are a founder and the investor comes with a lot of money, you just don't have that much money to actually pay it in yourself, and then the preferential subscription rights are not exercised. Preemptive rights. Under Estonian law, there is a preemptive right granted by law. This means that if you are a shareholder and you want to sell your shares to a third party, so somebody who is not a shareholder of the same company, you can do the share transaction, but within 1 month, the other shareholders can come and tell you that, hey, I want to buy those shares myself. So it's a post-fact right of the other shareholders, and this creates problems. Because if you have already sold the shares, it might be very difficult to get them back from the original buyer. So you see where the problem is, like in this regulation already. So in most Estonian startups, if you look at their articles of association, the preemptive rights are waived, so they're not used, just because they are very difficult to manage in this case. Instead of preemptive rights, the right of first refusal is used. This is a pre-fact right. So in this case, if I am a shareholder and I want to sell my shares, first I have to go to the other shareholders of the company and say, like, hey guys, I want to sell my shares. These are the terms. Do you want to buy them? If somebody says yes, then I just have to sell to the other shareholders. From my point of view, it doesn't really matter who buys if the terms are the same. I mean, in some cases, yes, it might differ whom I want to sell to, but from a monetary perspective, it doesn't really matter because I still get the same amount of money. It is simpler to administer than the preemptive right because the right is prior to actually making the sales transaction. So there is no problem of getting the shares back because I am still holding the shares at the point that I'm going to you saying like, hey guys, do you want to buy the shares? The right of first refusal in case of onboarding investors can be multi-tiered. So it can be so that first you need to go to the investors and say, hey, investors, do you want to buy? And if the investors don't want to buy, you have to go to the other shareholders and say, hey, do you want to buy? And if nobody wants to buy out of the shareholders, then you can sell them to the third party. Yeah, I do have a tag along sale as well, slide as well, just checking. Another right that is protective of the majority is a drag along right. Under Estonian law, the public limited liability companies have a squeeze-out regulation. So if one shareholder buys more than 90% of shares of a public limited liability company, they can tell the minority shareholders, hey guys, I'm going to buy you out. These are the terms, and they have to oblige. In case of a private limited company, no such regulation exists. So if the majority wants to sell their shares and there is no drag along right in the shareholders agreement, they have to individually convince all the minority shareholders that, hey, this is a good deal, you should take it as well. But if there is a drag along right, then the majority shareholders can tell the minority shareholders, like, this is the deal, you need to take it. So no convincing, so they can force them to sell. This protects the majority interest, because if the majority wants to sell and the person they are selling to wants to buy all the shares, then they're not happy with like 97% of the shares or 82% of the shares. They want the 100% of the shares. So drag along allows for the guarantee of such deal actually going through. Yep, the drag along majority can be at different levels. So it can be just a simple majority, it can be a qualified majority. For example, it can be said that, you know, it has to include both investors and founders. So no right or wrong way, again, just have it set at something. But on the flip side of a drag along, there is a tag along provision or co-sale right. Co-sale right is for the protection of minority investors. This means that if the majority shareholders are selling their shares, then the minority shareholders can tag along and also sell part of their shares. So this depends on how much the majority shareholders are selling, so that much the minority shareholders can also sell. This guarantees for the minority shareholders that, you know, they don't get left behind. If one of the central shareholders exits, then maybe the company is not worth that much anymore, or the minority shareholders would also like to liquidate some of their shareholding. So this is why a tag along is a good provision. However, I must tell you that I have never seen it used in practice in my almost 8 years of practice now. But it is included in most of the agreements with the investors. Next up, I'm going to be talking about the option pool. So the option pool means that there are a certain number of shares reserved for granting options to employees of the company. Options generally are just a promise that, you know, if you are our employee for an X amount of time, we will give you a part of the company. Basically, this is a motivational tool for the employees because people tend to care more about things that they own. So if you give your employees part of the company, they are more likely to contribute more towards their goals and the achievements that you want the company to achieve. In startups, this is also like a hygiene factor. So if you are recruiting IT guys, then you don't really get by without options. There is a hand up again, go.
Is it just a promise? Do they ever get really shares of the startup, and how much is okay to share? How many %?
At first, it is a promise. But, you know, in the promise, you say that I promise you that you will get these shares if you do this. And when they have done the either like performance-based goals, or if they have just stayed with the company for a certain amount of time, then they will actually get the shares. How much shares to give to the employees? Well, Yet again, it depends. Generally, the option pool size is 10 to 15% of the share capital of the company. So if you have the typical Estonian company of 2,500 as the share capital, then if you want to have a 10% option pool, that would be 278. So, and then your fully diluted share capital would be 2,778. The size of the individual option granted to the employee also depends on when they join the company. The earlier employees have bigger options, the later the employee joins the company, the smaller the risk, the smaller the option. Well, this is the general understanding, but you can also modify it as needed based on the people that you're hiring. So as I have said many times already before, a stupid lawyery answer, but it depends, but it really does depend. And regarding the option pool, the size of the option pool also depends on what do you do. So if you are running a purely hardware business, then you might not need an option pool at all, or maybe need a very small option pool. But if you're running a SaaS business or a platform as a service business, then you generally need an option pool roughly in that 10 to 15% bracket.
Sorry, Kati, why
Yeah.
do you say that if you run a hardware business, you don't need an option pool?
I mean, this depends how you want to build your company, but generally in the hardware companies, I have seen small option pools or no option pools at all, because they have found other ways to motivate their people.
Okay, interesting.
I mean, if your engineers are asking for options, then you probably need to provide them.
Okay, thanks.
What is very important regarding options is taxes. And if you are running a born global company and you're attracting talent everywhere, you also need to be aware of the option rules of not only Estonia, but also other countries that your people are working from. Estonian law taxation is rather straightforward. There is an exemption granted to stock options that if the period between granting the stock option, so signing the option agreement, and exercising the option, so actually issuing the shares to the employee, is 3 years or more, there is no taxation on part of the employer. So the employer doesn't have to pay any taxes. You get to grant the shares to the employee if there is a 3-year period. If the period between granting the option and exercising the option is shorter than 3 years, it is considered a fringe benefit, a non-monetary compensation to the employee, and it is taxed heavily. It is taxed with income tax of 20% and social tax of 33%. So the tax burden is very heavy if the options are exercised prior to the 3-year period elapsing. However, if you are successful and manage to have an exit prior to the 3 years, then the options can be exercised tax-free pro rata to the period that has passed. So, for example, if you get an exit in 2 years' time, 2/3 of the options can be exercised tax-free. But if you allow your employees to exercise the options in full, the 1/3 will be considered a fringe benefit. The basis for the taxation of fringe benefit is the value of the benefit. So even if you may be granting an option to a share with a nominal value of 2 euros, but if the actual value of it is 200,000 euros, you would be taxed on the 200,000 euros. So this is why it is a good idea to observe the 3-year period under Estonian law if your employees are based in Estonia. If your employees are based elsewhere, You might, well, not might, you have to look into the tax laws applicable there, because some jurisdictions require you to set the fair value at giving the option or have other taxation provisions. So just something to keep in mind. Confidentiality clauses. This might seem like a boring or, you know, just copy and paste through different agreements, but, you know, it's not so. You want to protect your business secrets. You want to protect what makes your company unique. So this is how you do it. You protect it through confidentiality clauses in the shareholders agreement. And you should also have the confidentiality clauses in other agreements that you conclude, under which you actually give out your business know-how. Confidentiality and the confidential information should be defined. You can't say that everything that I say is confidential information. No, it's not. And how to protect against infringements is contractual penalties. So if you don't have a contractual penalty, it is very difficult to quantify the damage that you have suffered as a result of the confidentiality breach. So if you have a contractual penalty, let's say that, you know, if you breach the confidentiality obligation, then you have to pay 100,000 euros. You only need to show that the confidentiality obligation was breached. And then the other party is liable to paying the contractual penalty. However, if you don't have a contractual penalty, and then you will have to sue for damages. And in case of damages, first you need to show that there was a breach, then you need to show that there was a damage, you need to show that there is a link between the breach and the damage, and you also need to show the amount of the damage, which might be very, very difficult to show, because once the confidential information is out, then how can you say how much you actually suffered? It's very difficult to quantify, for example, the lost business or the monetary value of the information. So this is why having a contractual penalty is a good idea, and having the contractual penalty set at a higher amount. So 5,000 euros might not cover anything. Even 50,000 might not cover anything. Just something to keep in mind. Next up, non-competes. Yeah, hand up again.
Sorry for interrupting.
No.
And then how much to make this penalty? How much is reasonable penalty?
Well, you'll have to look at the value of the information and the possible damage that you can occur if the information gets out. If you are, for example, if you are looking to have a patented technology, then the damage can be like in millions. But, you know, if you are just starting out and your business is maybe not that unique, then the damages might be smaller. So just have it on the higher side, but I can't really tell you like a set number that works for every case. Generally, it is in the tens of thousands, like starting from tens of thousands of euros. Next, how you want to actually protect the uniqueness of your business and the possibility of having less competitors. Non-compete obligations. So these are obligations that the founders are subjected to. If you have investors on board, especially financial investors, they will not be subjected to non-compete. But founders, yes, they will be. A non-compete allows you to protect the business and the advantages you have already in the market. For example, if you are the first one to go into the market, then you have the first commerce advantage and you would want to protect it. But if somebody leaves from your team, you don't want them to leave your team and then the next day start a competing business. This is where the non-compete kicks in. Generally, non-compete applies during the term of the shareholders agreement and also for a period after the shareholders agreement has terminated. So after the person has left the company, then for a certain period of time, the non-compete will still apply. The non-compete under the shareholders agreement and the employment agreement is a bit different. If under Estonian employment law, if you want the person to keep adhering to the non-compete obligation after the agreement has terminated, you have to pay them compensation. But under shareholders agreement, no such requirement exists. So the shareholders can be subjected to the non-compete without paying any compensation to them after the termination of the agreement. Generally, the period after the agreement has ended is up to 12 months. There is a hand up, Jürgen, go.
This non-compete, when the founders are working on a same field previously and then they come together, and can this non-compete also used to bring everything they have done into the new company?
So if I understand you correctly, then the founders are currently working in some field, but they want to have a startup in the same field.
Yes.
Well, then you have to look at your current agreements, what your current agreements allow you to do and don't allow you to do. Obviously, you can't bring your current employer's business secrets. But if your current employment agreement says that you can't compete with the employer in the same field that the employer is engaged in, then you can't do the startup.
Okay, but when there's no restriction from the current employer because they are the employers also.
If the current employer doesn't restrict you, then go ahead.
Okay, but I would like that my partners are not doing the same thing on their own also, or as a freelancers. I want them to concentrate into the company, and probably they also want me to do the same.
This is a founder's devotion clause, usually saying that the founders devote either their entire business time or 40 hours per week to this company. And in the non-compete, it says that during the agreement, you're not allowed to compete either like solely through a third person or through as a service provider. So that basically covers it all.
Okay, thanks.
Before Jürgen's question, I said that generally the term of the non-compete after the termination of the agreement is 12 months. I have seen it pushed up to like 24 months, but generally the 12-month period is used. Non-solicitation. This is the one provision that protects your team. So yes, somebody leaves, but you don't want them to take your team with you. So non-solicitation provisions say that if you leave the company, then you can't solicit the employees, the service providers of the company to work for you in any capacity. This is especially important at the current climate that we have when there is less people than needed. So this is important in that sense. The non-compete and non-solicitation are also mostly enforced through contractual penalties. And the contractual penalties in these cases also tend to be on the higher side. On the same reasoning that's used in the confidentiality contractual penalty clauses, that it's very difficult to quantify the damages that you might suffer in case of a breach of non-compete or non-solicitation. And then there are just some reps and warranties saying that nobody is bankrupt, nobody's in a conflict of interest and such. And then just general boilerplate clauses about how do we actually amend the contract, can the rights and obligations be transferred, what kind of law applies, where do we actually resolve the disputes. So any such clauses are also included. Other clauses that might be included are anti-dilution, but this is purely if you have founders. Not founders, sorry. If you have investors, then you might have anti-dilution. Anti-dilution means that when the investors come in, they pay a certain amount of money per share of the company. And when things don't go as well, and your next round is priced lower, so the newer investors pay a lower price than the previous investors, then the previous investors don't get diluted, so their shareholding won't diminish as much as if it would when no anti-dilution would be granted to them. But if the new investors come in at a lower price, their shareholding gets upped a bit and the founders get more dilution. This will come into play if the economic downturn becomes a reality and the window of the sales of the startup sector will be taken out a bit, but we'll see. But this is just something to keep in mind. Founder lock-in is also usually required by the investors. This is a provision saying that for an X amount of time, the founder cannot sell their shareholding in the company. This is also used to ensure that the founder actually is in the company and is doing things for the company. Deadlock resolution, as discussed earlier, more important in case of 50-50 splits, but also might be needed in other cases. No right or wrong way to go about it. What else do you think should or could be included in such an agreement? Well, this is something that you can think about at home, or maybe come back to me during the mentoring sessions that I will be holding tomorrow. So there is no 7-minute break. There is just the possibility for you to ask questions right here, right now, and then I will just talk briefly about the cap table and how to set up the cap table, what to do and what not to do.
Yeah, Kati, I have actually a few questions.
Go.
Let me just see. Let's say it's a question about my previous company.
Mm-hmm.
So so it's a startup company and we have investors on board.
Mm-hmm.
And now we need actually to shut down the company.
Okay.
But it's not an Estonian company, it's a Dutch company. But still,
Okay.
do we need an agreement from the current investors? And we got them as in the form of the this safe mechanism.
So they are safe investors.
Safe investors, yes. So do we need an agreement formal agreement from them to shut down the company?
Generally, under safe, it's not required.
Okay.
But you will have to look at your current safes that you have concluded. But in most cases, under safes, it's not needed, and you can just shut down the company.
Okay. Yeah. Thanks. And a few more questions. Let's say, now we're working on a new company, but it's not even registered and nothing is yet on paper. So I wonder, for this situation, can be any claims made in the future or based on the Estonian law, or it's only can be made if there is something on paper?
Well, it's very difficult to make a claim if you don't have anything written down. So in case of court, I mean, it boils down to proving your claims. And if you don't have anything written down, it's very difficult to prove. So I can say that, yes, I did that, but as saying, you can say, no, you didn't. And if you don't have any written proof, then it's just like he said, she said, and it will be a very difficult dispute.
Okay. Okay. Can I have 2 more questions? Yeah.
Happy to answer.
Yeah, thanks. Let's say a company we register in OU in Estonia. How easy is that to add later co-founders in the company?
Yes, it's possible.
Is it very difficult and time and money consuming?
Well, under Estonian law, the easiest way to do it would be to issue new shares and increase the share capital of the company. So, for example, if I establish a new company with a share capital of 2,500, and then it's registered, everything's good, and then I want to add you as the other shareholder with a shareholding of 300 euros. Then I can just increase the share capital from 2,500 to 2,800 and issue you the new share. And it's not very difficult. It requires a shareholders resolution, payment to the bank account, and then a commercial register application.
Okay.
I can also just sell you some of my shares. But in most cases in Estonia, this requires us to go to the notary and pay the notary fee, which is not like super high, but still something to take into account. Okay.
And the last question. So what I understand, if you register a company in Estonia, then there are some standard templates when you go through this, kind of official electronic process.
Yeah.
So the question is at which stage do you need this kind of tailored documentation for your company?
Well, I would say that if you are alone, then definitely you don't need it. If it's just like 2-3 of you, then you probably also get by with vanilla articles that the commercial registry process allows you to just like click through. But if you have more people and it becomes more complex and you require more tailor-made solutions, then you do require this to be done specifically for your case. Okay. But when you are starting out, then you can do the vanilla articles and run your company based on that.
Okay. Thank you very much.
I also have a question, if possible, about the last question, actually, from Joseph. So is that the case when there's no other sort of like value to the company? I'm just wondering, because right now, okay, let's say I already have the revenue in the company, I own the company 100%, and I want another person to join as a founder. Would that still go with this 2,500, or would there then be this sort of like valuation of the company and of the shares?
Well, if you want to add the new person, then, first of all, it depends what kind of a position you want them to have. Do you want them to be on the equal footing, or you want to give them like 10-15%? So that's the first thing. But, the articles and the complexity of the articles is not dependent on how much revenue the company makes or something like that. It depends on the shareholder structure and the shareholder relations. So if you are bringing on a late co-founder, you said that your company's founded already has a revenue, so then I would call them a late co-founder. Then you probably want them to have some obligations that you want to have in the founders agreement, and also the reverse vesting provisions in that case will be very fitting, I would say, because you're bringing them on, but you want to test them and see that they are the right fit. So I'd say you necessarily don't have to change the articles, but you might really think about having the founders agreement in case of onboarding a late co-founder.
I'm just thinking, you know, when an investor comes along, then like obviously when they evaluate the company for like 1 million, or this is like typical for SaaS as well, and then they come in with 100K for 10%, right? So I'm just wondering, of course, with founders and with employees, there's this non-monetary part as well. But if I want to, at least to some parts, go for monetary, like share selling or I don't know, adding as well, then should I go for the evaluation? So should I start evaluating the company based on the revenues, or should I just go with what is the capital right now? It's actually, yeah, for me it's a bit more than 2,500.
I mean, if you already have revenue, then your company is definitely worth more than the share capital. How
Yeah.
to evaluate the company is a whole other topic. So, but you know, if you want the late co-founder to also pay in some part in like cold hard cash, then I think that having a valuation to your company saying that, you know, this is where I see that the company is now, you can agree or disagree with that, but you know, these are the terms that I'm presenting to you, that would make a lot of sense.
Okay, thank you.
Any other questions at this moment?
Convertible notes will be on this topic, yes? Or just...
I don't think I have time for this, but if you have a very specific question, go and I can answer this.
Yeah, I just want to clear out those, for example, 10, 11, 12.
Can you speak up a bit? It's very difficult to hear you.
Oh, sorry. Those 10, 11, 12% of convertible notes, how and when they are issued? Don't understand from those letters.
I still heard you not so well, but I heard that you want to ask like when the convertible notes are issued.
We'll try to write on comment.
Yeah, please write in the chat. Just so that everybody would be, you know, on the same page. Convertible notes are instruments that allow the company to have financing, but not give out equity at the time of getting the financing. So the idea behind a convertible note is that the company takes a loan from the investor, but they have pre-agreed on terms on which the loan can be converted into equity at a further point in time. And an upside for the investor is that convertible loan processes are generally easier to conduct, take less time, take less money, and that they will get a discount from the future round when there is actually equity coming in, like equity investment coming into the company. It is rather common in the financing world, but at one point, if you only have convertible loans and not a lot of equity, then your balance sheet is very tipped, and you are required to take some measures to conform to the laws, actually. So that is like a point against using a lot of convertible loans. I don't think the message is incoming. Okay, two type of. I don't really get what you're getting at. Are you talking about like fixed percentage convertible notes? in most cases, convertible notes set forth a valuation cap and a valuation floor. If you are dealing with a fixed percentage convertible note, then I think that these percentages will work like valuation cap and valuation floor. So in that case, if the note comes to maturity, then you would convert at the valuation floor, which would mean the bigger percentage. And then if there is an equity investment, then it would convert into the smaller percentage. Is this what you're getting at? Okay, great. But I would also like to note that fixed percentage convertible notes, at least in Estonia, are uncommon. I know that, for example, Techstars in their acceleration programs uses a fixed percentage convertible note, but I haven't seen a fixed percentage convertible note under Estonian law. It is possible, but you know, as a founder, you might not want to have a fixed percentage convertible note, but rather leave it up to the valuation and the equity investment that you get in the future to determine the percentage of the shares that you're giving to the convertible investor. But both are possible. Any other immediate questions at this point? No. Well, then I will just briefly touch upon the makeup of a cap table and show you some examples of cap tables, also real life examples. So you'll get to see how the percentages of founders will actually diminish as the rounds go on. Okay, yeah, so the cap table shows the equity capitalization of the company, basically who owns how many shares. Usually the cap tables are kept in Excel, but there are multiple software solutions that allow you to have cap table management tools, but you need to pay some money for that. And in most cases, cap tables are not as complicated to warrant the use of a special software. And you can also use the cap table to project how your cap table will look like in the future rounds. Basically, thinking of what if I get this investment on these terms, and then see how the percentages and the ownership changes. So here is one example. This is a real life example again. Here you can see that this is a post first financing, and the founder and the investor have the same amount of shares, basically. This is not a good cap table. Don't do it. Because if you have such a cap table, it is very difficult, if not impossible, to get future investors besides the investor that you have already. Why is that so? Because the investor has a very big chunk of the equity, and if there is a new investor coming in, the founder shares get diluted, their interest in actually doing the company might diminish. So not a good idea. Like a rule of thumb is that don't give away more than 20% in any round, but as I said, life makes its own ways, so you might have to do bigger or smaller rounds, but just keep in mind that don't give away too much in the beginning. And as you can see, there is also the option pool of 12%, which is like a rather okay percentage to have as an option pool. Second is post-seed round. So here in this cap table, there have been already like 2 financing rounds. First, the pre-seed round, and then the seed round. There can also be like as the very first financing round, the friends, fools, and family round, but this was not the case in this case. Here you can see that the founders hold like 52%. The first round, the pre-seed round, shareholders hold like 14%, and the new investors will hold almost 26%. This is an okay cap table. The founders are 3, and the 52% is split basically equally between them. But this is an okay cap table after a seed round. So the founders still hold the absolute majority of the shares. And the investors hold a big chunk, but not most of it still. Post A round cap table looks a lot different. Here you can see that the founders hold only 37% and the investors hold the absolute majority already. And the option pool is 11%, which is rather standard. But in these cases, if the founders lose the absolute majority of the shares, then there are contractual clauses that need to fight against this, that the founders won't be forced out of their own company. So this needs to be taken into account, that if you as a founder fall below 50%, then you need to counteract this so you won't be forced out of the business that you are actually running. And the post B round cap table, yeah.
And how do you do that?
For example, through having a qualified drag along majority, saying that in order for the drag along majority to be effected, then the founders also need to be on board, or at least majority of the founders. You can also have founder veto rights regarding the mergers and the asset sales and such. So these are the contractual ways to counteract this. In this post B round, the founders have like 22% and the investors have 68%, but there is still option pool. So there are still team members that are becoming shareholders at future points in time, but the founders are holding only 22%. But they're not unhappy with the 22% because their 22% is worth way more than the 100% that they held in the beginning of starting to do the business.
So it's okay. It looks okay?
Yes, this is okay. There have been, in this cap table, there was an A round. Before that, there was a seed extension round. There was a seed round. There was some friends, fools, and family money. So there is a lot of investors in this case with the 68%. A hand up, please.
How does it change? Why founders lose their shares and investors get more? Like, does they agree on it or it goes automatically?
Yes, it is agreed. I mean, in this case, the investors put in like tens of millions of money to get this shareholding. So, like, principally, if the founders themselves had the money, they could just put in the money themselves and not lose the percentages. But, you know, realistically, you don't have tens of millions of money yourself. So you take the external money and you dilute your shareholding. Did I answer your question?
Yeah, thank you.
Okay, great. I also have an exercise here, but I'm just going to show you the outcome of the exercise. So first, there is a nice three-way split. Then there is a first investment, which dilutes all the founders from 33% to 27%. Then there is another investment, which dilutes them to 21%. And on the third investment, they are all diluted to 17%. So this is basically how it goes. So in the beginning, 33%, but at the end of third, like the A round investment, each founder holds 17%. So this is just something that I made up. So this is not based on real life. I just made this up, but something for you to take into account how the cap tables change over the course of the life of a startup. So,
sorry, I have a quick question as well.
Yeah.
So in Estonia, it's typical to use the capital as the shares, because I've worked with Americans, and they usually put like that the starting point is 1 million shares. So yeah, my
Yeah.
question is like, what's common?
The Estonian company law logic is different than the US. So in the US, at first you're starting a company and you're authorizing like 1 million shares. But in Estonia, you need to have a fixed share capital for the company. And then you are issuing new shares. So this is just like a difference in how this is approached. But, you know, generally in the end, the outcome will be the same.
Yeah, okay. So we start with the 2,500 as this is the amount of shares, and then start, you know, playing around with them, right?
Yeah. I mean, you don't have to start with 2,500. You can start at a higher
Yeah,
amount
yeah,
as well,
but
you probably don't
yeah.
want to put in million euros.
Yeah. Okay.
Okay. So
Maybe a quick question, Kati.
Yeah.
The previous slide. Sorry, one before. So I guess a bit greedy question. So let's say at this point in time, can founders say, "Oh, we can actually take part of the option pool to ourselves," or not?
at some points it is used so that the founders are issued options, but in this case it hasn't been used because the founder shareholding is okay. But if, for example, the founder shareholding is on the verge of not being enough in earlier rounds, then the founders are sometimes issued options from the option pool as well.
Okay, thank you.
Okay. This is the end of the slideshow. But I am still happy to take a few questions if you have any. And if you don't, then you don't.
Maybe some experience about slicing pie service.
Yeah, slicing pie is a philosophy for those who don't know. Slicing pie is a philosophy that you don't distribute the equity at day 0 or like day 1 when you start the company, but at a later point when you know better who has put in how much effort. Slicing pie has its pros, but it also has its cons. I mean, I think the biggest con of slicing pie is that everybody needs to be on board. Everybody needs to be committed and like the same amount of commitment to using the slicing pie method. So slicing pie method requires you to track everything that you put into the company, like all the time, all your networking resources, all the money. So, and somebody has to everybody has to put it in. Somebody has to administer it as well. So, I mean, on the administrative side, slicing pie is, I think, rather complicated. I have seen it run in Estonia as well, but I mean, it does make the administrative side very difficult, and it does require a lot of commitment. So if you and your team members are willing to put in the work that it takes to administer the slicing pie method, then go for it. But if not, then don't. Because if you let the ball drop on putting in the hours, then you're just hurting yourself. But you know, it happens sometimes.
I also have on a similar topic a question. How common is that, let's say, if there is a late co-founder to offer like a piece at first on the first day and the other amounts as like within a vesting period, or in general to have, I guess this vesting is the same as for the slicing pie. Is it the common practice, or to bring in some new employees with a bigger share, with vesting?
For the employees, I definitely recommend you use the options. So because options at first, before they are exercised, they are just a promise. So it's easier to say that no, this promise is not any good anymore than start taking away something that you have already given the person. So use options as much as possible in those cases. And also for the late co-founder, if you're ready to negotiate, having the setup so that they get like a smaller percentage now, but then some percentage as options when they have actually proven their worth is also a very good approach to take.
Mm-hmm. Okay, thank you.
And Kati, are there any kind of standard templates for this, option for ESOP? We're talking about ESOP, right? Document. Yes.
The Estonian startup community has very good templates. They are on startupestonia.ee. There is an option agreement. There is no like option program document, but it's rather simple. So you can look at those documents. They are very nice documents, but since it was Estonian Venture Capital Association that ordered the drafting of these documents, they are slightly in favor of the investor. And if you are having your first investments, then they are way too complicated. But if you are thinking about having a founders agreement, then the founders agreement template there is very nice and usable. So that I encourage you to use, but for example, the shareholders agreement is way too complicated at this early stage.
Okay. It sounds so evil.
Welcome to the startup world, right?
Yeah, exactly.
Any other questions?
I just to say that, guys, those of you who would like to talk with Kati tomorrow, there is a little bit rescheduled time. Please recheck it and reconfirm that you know when you start to understand the legal issues of absolutely evil startup world. That's why we have created unicorn idea, just to attract you here, and then you will get into these jungles.
I mean, I think every jurisdiction is evil in that sense. So, yeah. But Estonia is very favorable on the taxes, so that's rather nice. And the digital society just helps a lot. So administration in Estonia is way easier than maybe some places, somewhere else. But in the end, at the end of the day, it depends where you want to do your business, where your clients are, where the money is, what you're after. So these are all factors that you need to take into account.
Yes, but I'm really, really suggesting you that re-watch this video and understand that sometimes you decide that, we are friends and never ever happens, no bad levers. But the most evil, the biggest evil comes when the first euro will drop on your account and you will start to share this money. There's real money. The shares is like 1%, 3%, it doesn't matter. But the real struggle starts when the real money starts to come. So just be aware about it. And all these papers are just because of it.
Yeah, if everything works out smoothly and you never get into any disagreements, no need for any agreements. But, what I see that things get complicated when things go bad or when things go really well.
Yes. And I've seen when people are starting to go to the courts because of like really small money and they claiming these confidential rules and they are claiming the bad living and like everything. So, and sometimes Kati is perfect lawyer, but sometimes the other lawyers, if you pay them, they can write whatever, that the wind is blowing from the land to up to the sky, and they can create this juridical logic in this kind of papers. So just be very solid in your first papers.
And also later.
And later you have already lawyers.
Kati, I had a question. So a practical question. So let's say I need a shareholder agreement. So I will probably need your help, I guess, to create a better one. What's the best way to get in touch with you?
Email. I think Jana has all my contacts, and I will share with you the slides as well, and I will put my contacts at the end.
Thanks.
But they're very easy. Kati.pino@hedman.legal.
Yeah, you can also add me on LinkedIn. I am friendly, I promise.
Kati is super friendly.
Thanks.
I also have a question, like, let's say, because for tomorrow I won't probably have all the contracts to, like, there won't be any time to go through them anyway. So let's say one good day I will have a lot of legal documents to look over. How do you usually work with that? So do I contact you, and then there will be some sort of consultation to go over this, or like how does it work usually?
Yeah, I mean, generally, if you already have documents, then we can go over the documents that you have and make them better. If they are really bad documents, then sometimes it makes sense to start from scratch and then just redo the whole document. Yeah, I mean, yet again, it depends on the situation and on the circumstances. But yeah, if you have something already, then great, we can have a look at it, tell you if it works or it doesn't, and just go from there.
Thank you.
Okay, so there's no any possibility anymore to talk with Kati because she has like all the slots busy. But those of you who will win Protatron, you will get voucher from Hedman Partners, so you can be on the safe side to check your papers and to go further very smoothly. And you always can, of course, or just go to Hedman and order their services.
Or look at our webpage. We also have some questions answered already. So there is a lot of free resources floating around. So you just need to know how to make the best use of them.
And just read them. I mean, and of course, this is how these legal guys earn their money. They read a lot.
I can actually give my time to somebody, because I was very optimistic and thought that I could prepare some things for tomorrow, but I didn't have the time. So if anyone needs, then.
But Kirke, it will not be tomorrow. If you check the table, it's on the 1st of December.
Oh, that changed. Okay, I saw the time changed. Okay.
No, please, guys. Vice Clean, Player Bank, Scopus, Moonclone, Kinola, the Agency of Understanding, Snow Recycle LLC, and Yoo-Hoo. Please recheck your schedule, how you can fit into the new schedule of Kati.
Then I will have time.
And if something in the channel in random, you can play around. Don't violently just delete someone, okay?
Yeah, please be respectful of each other.
Okay, then I will leave you with all these thoughts about the money, about this